Hello everybody, I'm Jim Martinucci. We're going to start the meeting. It's 7:05, so I call this to order. The Zoning Board of Appeals has a quorum. 3 makes a quorum, we have 4. John, Norm, Dave, and myself. Roger was here the last time we were here as a board, and he's not here tonight, but we still have a quorum. We are here on the appeal filed by the Boys Livestock Inc. And I want to say for the record what we have, but before we do, I want to make sure I know who's here. Mr. Fetter?
Yes.
Right, and then there are gentlemen with you from the board, is correct? Same 3 gentlemen that were here last time?
Okay.
Could you just state your names again so I don't mistake the
Randy.
first names?
Rick, Du Bois.
Thank you, sir. Sirs. We get members of the planning board here. We got the town planner here. Wendy's here. And the code enforcement officer is here, I think, is he? Just stand right at this right. So let me just say for the record the information, the written materials that we have. We have, as a board, a administrative appeal application in a blue binder, or binding. We have what is entitled a supplement to the administrative appeal. We have what's called a second supplement to the administrative appeal. From the planning board, we have a document on the front page dated November 8, 2015 regarding the reapplication of the Boys Livestock LLC for administrative appeal. The planning board decision, it has some attachments to it. We also have, since the last time we were here, findings of fact concerning the September 29, 2015 hearing that was signed, I believe, on October 20th, 2015 by me as the chairman of the board. So, first of all, before I go to any certain issues we must address, have I not stated everything that we have?
Yes.
Yes, sir.
We would also, the town would also like you to consider the submission we made on September 28th as part of the packet.
So the submission that you made prior to the September 29th hearing?
Correct.
Yes, okay. And Mr. Fetter, were there documents that you submitted that I did not cite?
I don't believe so. I believe you got everything.
So I think the first thing we should discuss as a board is our jurisdictional issues, whether or not we believe as a board we have jurisdiction to hear this appeal pursuant to various provisions within the land use ordinance, so timeliness of the appeal. So I open that up to discussion among the board.
I think you've got 2 issues that we need to decide. I think you've got to decide whether under section 10.3.c, whether the 30-day requirement has been met with respect to the appeal. And I think there's also an issue given how the last hearing was decided, whether or not under 10.7.A, there's an issue with respect to this appeal already having been decided, and whether or not hearing the appeal tonight violates the 2-year jurisdictional bar with respect to any further appeals that concern the same issue or issues brought before the board initially.
So the first section that you cited, John, was
3.C.
And that states that any agreed party may appeal the decision of the code enforcement officer, planning board, or review board within 30 days after applicant has been notified of the decision as follows, right?
Yeah, I'm on page 187.
Right.
Those follow home.
So based upon the documents that we have, the issue is whether or not there was, one of the issues, is whether or not there was a timely appeal made from the Arundel Planning Board's decision on August 13, 2015, correct?
Correct.
I think there's a sub-issue to that, whether or not we consider that a true decision, or do we then look at the planner's letter to the appellants dated September 2nd, 2015. But either date, we should be running 30 days from that. Agree with that?
Yes.
Okay. Any board members want to talk about whether we should be running the date from August or from September? What do you think about that?
last meeting, the town council gave us some advice, and to have her opinion on it, and see.
So I want to make sure I understand what you're asking. Like, you're
Well, I'd
asking-
like to ask her, you know, if they met the 30-day deadline, basically, what we're trying to decide.
I think the first question though is, are we, and I think in 30 days, the math is going to be easy, but I
Yeah.
think, are we deciding from August 13, 2015, or are we deciding from September 2nd, 2015? Either way, to me, I think you just join on 30 days is 30 days.
Yes,
So
yeah.
30 days from August 13th, 30 days from September 2nd is not October 19th, so October 19th would have been late. And the reason it would have been late is because we were here on September 29th, I'm sorry, I think that's the date we were here. Yes, September 29th, and that's when the appellants walked out of that hearing, and we made our findings of fact that we were going to be with evidence. So what do you guys think about that jurisdictionally? Do you think we have jurisdiction to hear this appeal? To me, that's a fundamental question that we need to answer early.
I can add,
Okay.
30 days, no matter what date that you use, is not permit.
I agree with that.
It doesn't matter which date we use. In this situation, we can use a letter.
I think the same thing.
We discussed this in our last meeting.
Right, we did. And under 10.5C.4, because we had decided in our findings of fact that the appeal was withdrawn last time without prejudice, it gave the appellants the right to refile the appeal. But giving them the latter date of September 2nd to appeal from, that still brings them to October 2nd to file an appeal. This appeal is dated October 19th. So I think it's late. I think we don't have any discretion under this ordinance. 10.3.c makes it very clear that it must be within 30 days after the notified decision. And just so we're clear, what I'm referring to when I say September 2nd, is there is a letter dated September 2nd, 2015 to Du Bois Livestock at 2 Irving Road, Arundel, Maine, sent by both U.S. mail and email from the office of the town planner, Chad Redway. It discusses the August 13, 2015 meeting where the board, meaning the planning board, determined that the application materials submitted on July 10, 2015 for the renewal of the February 24, 2011 conditional use permit for a solid waste processing facility was incomplete. And then it listed certain deficiencies, 3 deficiencies. So, again, unless you want any more discussion on that, we should entertain a motion on that. And I wanted to talk about something else, but did you think your question, did you want to pose a question to the town lawyer?
Yeah, just her opinion on the whole thing.
Sure, and I'm happy to give it, and I just, as a point of procedure, I think, before you make a motion, perhaps you might want to hear from the applicant
That's a good
on
point.
the issue.
I agree with that.
So, with respect to the timing, then, we're going back to those provisions that have been cited. And really, it's about whether or not the appeal has been made, and I'm just quoting here, 30 days after applicant has been notified of the decision being appealed. Okay, so I think what you need to do, and this board has to make that decision, is whether there was a notice, what you believe notice is. And, you could find that to be notice of being present at the meeting and hearing it, notice of it in writing, but as you said, you've already discussed that, and you can make your own mathematical calculations as to that date. Now, I think the applicant will probably, and Mr. Fetter is perfectly capable of making his own arguments, but I think what another issue to consider is under 10.5C.4, which under your findings of fact last time around, there was that determination that it was withdrawn, and that the specific language is that it was withdrawn, and this is the ordinance I'm reading from, without prejudice to refile. So I think you need to to discuss amongst yourself what that means without prejudice to refile. Does that mean that, okay, they withdrew and there's no prejudice and that they can refile it at any time? Or does that mean that, well, still the governing appeal periods still would apply? And I think those are the questions that you need to discuss amongst yourself and make a determination on, after perhaps hearing from the applicant on those issues.
So I agree with that. I think probably what I didn't say it as clearly as the town attorney just said when I was referencing earlier that 10.5 on C.4 regarding withdrawal without prejudice, and then I went back and discussed that, in my opinion, they have the right to file another appeal because it was withdrawn without prejudice. But the question then becomes, do we stick then with the ordinance and it's 30 days from August 13th or 30 days from September 2nd, or is it 30 days from another day? I don't see that it's 30 days from another day. But I do want to hear from the applicants on it. So, Mr. Feder, do you want to comment on the issues of the dates?
Yes, I do. Okay, the statute is not jurisdictional in relation to 30 days, okay? I mean, it reads, such appeal shall be taken within 30 days of the decision appeal from and not otherwise, except the board upon a showing of good cause may waive the 30-day requirement. That means that the 30 days is not etched in stone, okay? It is not it is merely an advisory determination, okay, that you can make or change it at will. Now, the problem here is, okay, we have always contended we did not get notice. Okay, notice from the town planner, okay, that something has occurred in a planning board meeting is not sufficient notice, okay, to start the statutory period running. Now, we did file our documents within the 30-day period as we were supposed to, okay, and then we received a notice that within this 30-day period to come to this particular agenda and put on our case, except for the fact that it was a public notice, which we mistook to be a public notice, as opposed to a date set for hearing. Okay. At that time, okay, you determined that what we did was considered to be a withdrawal. Okay, you deemed it a withdrawal. Okay, based upon that, okay, you have to rely on the statute, okay, which deals with the result of a withdrawal. Okay. If a party does not attend a hearing and is not otherwise represented, its case will be deemed to have been withdrawn without prejudice to refile the appeal. To treat the 30 days, okay, as a factor within this particular statute, okay, creates a decision in which, okay, the appeal can only be filed with prejudice as opposed to without prejudice. So our contention definitely is, number one, we did not get notice. Number two, we were permitted to refile our appeal exactly as we did. Okay? And there, to find otherwise is to create an absurdity within the confines of this particular ordinance.
So, Mr. Feder, can I ask you a couple of questions?
Sure.
When you first started reading from the ordinance, I believe you were reading from 10.3.c about the 30 days, and you used the phrase that it's the board's discretion. Where were you reading that from?
I was reading from, it's in the ordinance.
I'm just asking if you can tell me where so I can find it.
It's the line, it says such an appeal shall
Section.
take, it's the same section, 10.5.
10.5, thank you.
I think that's where we got it.
So 10.5 what? There's a lot of 10.5.
I'm sorry, I must not,
Because I don't find what you're reading.
Okay, an appeal may be taken to the Board of Appeals by an agreed person from any decision of the code enforcement officer. Such appeal shall be taken within 30 days of the decision appealed from, and not otherwise, except the board, upon a showing of good cause, may waive the 30-day requirement.
And again, what section is that?
It should be in the...
It's 10.5A.
10.5A. But isn't that, aren't you reading about an appeal of a code enforcement officer? Aren't we talking about appeal of a planning board in this case? Which is 3C?
Yeah,
It
but
doesn't have that language?
I don't believe that particular, premise just deals with code enforcement officer issues. In fact,
I have another question.
yeah,
And then you said that, I think, you tell me if I'm paraphrasing you incorrectly, but you said when you read 10.5.C4 without prejudice, I think what you're trying to present to the board, and I appreciate what you're trying to do, is that if it's without prejudice, the 30 days kind of goes out the window, is that what you're saying? Because otherwise it would be with prejudice?
absolutely.
But then what do you do with the fact pattern that, let's give a hypothetical, you're appealing on September 2nd, you're appealing the decision that was made on September 7th, hypothetically, right?
Okay,
You appeal it on September 12th, right?
okay.
We schedule a hearing on September 27th. You decide to withdraw your appeal without prejudice. Aren't you still well within the 30-day window on September 2nd?
Well, the issue
Don't you
is,
still have time
well,
within that
whether
set?
you're within the window or not, okay, there's also the hypothetical where the 30-day period is expired before the hearing of the board is commenced.
And I totally agree with that.
Okay.
Then the question probably from this board would be, then why are you withdrawing? And that basically means you're waiving your appeal.
No, you're withdrawing it. Once it's withdrawn, okay, you gentlemen deemed it was withdrawn. We weren't waiving any appeal rights or anything else, okay?
I agree the decision of this board was you withdrew the appeal.
Okay, and based upon that, we relied on the statute that we could refile without prejudice.
It doesn't tell you that you can file without prejudice beyond a 30-day period.
But it says without prejudice, and that is unequivocal. And it doesn't say that the 30-day period applies. There's no qualification of that. And to find that there is a qualification undermines the issue of without prejudice.
Okay. Is there anything else you want to tell us about the timeliness of it?
I believe that, other than those two issues, dealing with the fact that we have given the original notice, okay? I mean, the 30-day period can't start because the town planner decides to send us notice when he's not qualified to do it. For instance, when we get notice from the zoning board of appeals, we get it from your secretary. The planning board had a secretary. She could have sent the notice, or one of the planning board members could have sent the notice.
That raises another question I have in my mind, and since you're the spokesperson, that's why I'm directing this
Well,
question
I
to you.
appreciate that.
Are you arguing to this board that the planning board didn't make a decision in August, and they didn't make a decision on September 7th?
That they didn't make a
They
decision?
did not.
A decision was made, yes.
So what were you appealing when you first came to this board? Which decision were you appealing? On September 29th, what were you appealing? A decision dated what date?
I'm sorry,
You filed an appeal on behalf of the boys. We were all here on September 29th. You were appealing a decision made by the planning board, correct?
Yes, by the planning
What
board.
was the date of that decision of the planning board that you were appealing?
That date, I cannot tell you right offhand, but I know that we were at the hearing, and they determined our matter incomplete.
So was that a date, even though I know you can't remember the exact date, I know it's not a memory contest, but it was a date in August?
No,
Was it eventually a date in September?
I don't remember.
Okay. But you were appealing some decision by the planning board that said your application was incomplete?
Right, and we also at that time indicated that we had never received notice, when we did file that appeal.
Okay. All right. So who's going to speak to us from the planning board if anyone wants to talk to us about the issue of timeliness? Yes, sir? And who you were?
My name's Richard Canal, I'm the chairman of the planning board.
Thank you, sir.
We had a hearing on August 13th to determine the completeness of the application. It was after numerous attempts. The town planner had notified them that it was incomplete. They informed the planning board that the town planner did not have the authority to do so. I then wrote them a letter telling them that the application was incomplete, citing the reasons it was incomplete. They told me I did not have the authority, the entire planning board had to have that meeting. So we met on August 13th, looked at the application, which was a 2-page application and missing all of the necessary attachments, and we deemed that the application was incomplete, and all 4 of the appellants were in the audience at that time. They knew that that application was incomplete.
And did the board make that statement out loud?
Yes, sir, we did.
Steve, it looked like you wanted to say something and I didn't give you an opportunity to say something.
Well, it just seemed to me that Sal was saying that he received notice, and he told us he didn't receive notice. He received notice from somebody that didn't have the ability or rightful authority to send it. Now, it can't be both ways. Either they got this by US mail and email, or they didn't.
Can I say something? I get two things out of it. First off, notice, you know, in almost any arena when it comes to a decision whether it will end up resulting in forfeiture, okay, like a situation like this, it must be a certain nature of notice. It must be sent out by a particular, you know, party within that group, okay? Otherwise, it's no good. It's no different than a summons.
That wasn't my question.
Okay.
My question was, did you receive this letter dated September 2nd, date signed by Tad Redway or not?
Yes, we did, but it's not notice.
I just asked if you received it.
Now, can I also mention something else? Mr. Gallon mentioned the fact that we insisted that the planning board make the decision. It is statutory or ordinance related. Our land use ordinance 8.10.E.1 provides the planning board, after determining an application is complete and appropriate fees paid, shall process the application in accordance with the procedures established for a conditional use permit. We finally got a hearing set in this matter in relation to our first application, renewal application. We filed it on December 9th, presented it, okay? It finally was brought to bear on the period on April 22nd, 4.5 months later. It was held hostage deliberately by the town planner, okay, who by statute had no reason to hold on to it because the planning board was required, okay, by ordinance, okay, to hear the matter in relation to completeness.
Mr. Chairman,
Yes, sir.
Ted Redway, town planner. That application was withdrawn willingly by the applicant, and we don't consider that that has any standing in these hearings.
Yeah, I don't really, Ms. Federer, all due respect to you, I don't understand how that April issue has anything to do with the question that we're addressing right now, which is, does the board have jurisdiction to hear an appeal that was filed on October 29th?
Well,
That's the question that we're discussing right
just
now.
on this one particular issue, okay, maybe it doesn't, but the issue involved here is whether or not the town planner, okay, of his own accord can give us notice, okay, and destroy our ability to appeal before this board. We do not think he has that power.
Any other discussions on the jurisdictional issue? Comments, questions? Do you want to make a motion on that issue?
I make a motion that we don't have jurisdiction to move forward with it. Timeframe is not on in section 10.3.c.
Second, is there a second to the motion?
I agree with you.
You second the motion?
Yeah.
All in favor of that? The issue, you have a question, do you? Before we move on that.
Nope.
No question?
That's good.
So all in favor?
Aye.
So that's unanimous. I do want to say something else, though. No, Mr. Federer, I have something I'd like to say, and I would appreciate, you can do what you want, if you want to walk out, but I have something I'd like to say. And it's not gonna be just up to me, it's gonna be up to this board majority decision. These applicants have been before us twice now. And I don't know what they intend to do now that we've decided as a board unanimously that they don't have jurisdiction to move forward with this appeal. But on the chance that they want to go to court and the court says our zoning board of appeals is wrong, I kind of doubt that's going to happen, but if they were to do it, I don't see any prejudice to us by hearing the merits of this appeal today. In other words, we ruled there's no jurisdictional issue. That's ruling number one. But let's hear the issues on whether or not this application was, hear from the planning board, hear from the appellants as to whether or not this application should have been denied or not. Was it anything, That's what I'm saying, it's my opinion, you don't have to do it.
No way is that gonna be able to happen. You just shut us down.
What do you mean I should, yeah?
We've been voted out. Our appeal, you determined is not jurisdictional, so we're out the door.
All right, so I want to just say that on the record, and I appreciate you saying that, Mr. Feder, and I appreciate your patience in letting me just offer what I offered, but to be clear, no one's voted on it yet, I've just kind of been one solo person raising that, but you don't want us to even discuss that as an option.
I don't believe you can.
All right, that's fair,
Count.
that's good for me, it's good, and I appreciate you saying that.
As much as I'd love to go through it, because I just love doing this sort of stuff. The way Dave Bergen looked at me, he said, this is just not gonna work. Because it would be wasting this board's time, because you can't make a decision on it, because you determined that we are not jurisdictionally.
It seems like a young man here is trying to get my attention. Do you want to say something to me?
Yes.
Okay.
I'm Ethan Robbins. I live here currently with Diane C. Robbins. She was on the news. I don't understand something.
All right, go ahead.
They put rules on that thing right there that's meant for another meeting. He, one of Du Bois' best friends, he has been kicked out of, he's technically been kicked out and shut down like he said. That's not fair to him, and also to us, because sometimes people need to live. They need to make money. And also, he also mentioned something about another meeting that wasn't supposed to be in this meeting, like you said. Like, who bring that up?
So young man, what's your name?
Ethan.
Excuse me?
Ethan.
What's your last name?
James Tilson Robbins.
Okay, so I appreciate your comments, but we're not trying to shut anybody down for making money on it. We said it at the last meeting. That's not the board's power, authority, desire, or intent.
I know, I'm saying that they shut him down. Well, they technically kicked him out.
Who's they?
The board.
Which board? Planning board?
Yes.
Well, that's not we're not deciding that issue, but I appreciate your comments. Okay, did you want to tell us something else?
I'm proud of you speaking out.
All right,
Yeah.
good. Thank you, thanks for being polite too. Okay.
He isn't an attorney one of these days.
He isn't using that word over here.
I'll keep the C warm for you.
Yeah.
All right, so the last issues are on this, to consider the approval of the minutes from the last meeting.
I need everything to go to the board.
I didn't raise my hand, but I said I raised the hand.
I have the minutes.
I thought we approved it by email. I didn't read it, so.
Yeah, motion.
Second.
All in favor?
That was very nice.
Any other business to discuss?
I got plenty, but I'm gonna save it all.
I'll let you say it to me prior.
That's right.
I'm being too generous. Okay, all right, everybody, thanks, we're done, we're adjourned. Thanks for coming.
What time are you closing? What time are you closing?